All right. Welcome, LSA attendees, to the second plenary of the day. I'm just going to wait for 30 seconds for everybody to sign on because I can hear the many people signing on. So speakers, just give us 30 seconds, okay? All right. My name is Penny Andrews, and I'm the organizer and chair of this panel. I'm also the president of the Law and Society Association. Welcome to this session entitled #MeToo, the narrative of resistance meets the rule of law. Before we start, I want to thank the Office of the Law and Society Association for putting this conference together. It's just been so far terrific. Thank you. And thank you all for attending this particular session. My job will be to introduce the speakers very, very briefly. I could speak to them, I could speak about them for some time. They're all experts in their field. They've written substantially on the subject. And then afterwards, I will hand it over to the moderator of the panel, Professor Judy Sook, and she will introduce the topic. So let me just briefly introduce the panelists. First, we'll start with the moderator. Judy Sook is the Dean for Master's Programs at the City University of New York's Graduate Center and a Professor of Sociology. She is a scholar of comparative law and society, with a focus of women in comparative constitutional law. Judy Sook is most known for her recent work on renewed efforts to ratify the Equal Rights Amendment in light of the theory and practice of gender equality provisions in constitutions around the world. Her dozens of articles and book chapters address the potential and limits of anti-discrimination law as a tool for eradicating social inequality. Her research interests broadly are comparative law and society, discrimination and inequality, women, work and family, comparative constitutional law, civil litigation as enforcement mechanism for public law, social, political and legal theory, and law and literature. The order in which we'll go after Judy Sook will be Brenda Cossman, who is a professor of law at the University of Toronto. For a decade, 2009 to 2018, she was the director of the University of Toronto's Mark S. Bonham Center for Sexual Diversity Studies. In 2012, Brenda Cossman was elected as a Fellow of the Royal Society of Canada. In 2009, she was awarded the Mandel Medal for contributions to letters and law. Brenda Cossman's teaching and scholarly interests include family law, law and sexuality, and freedom of expression. Her most recent book was published by Stanford University Press and entitled Sexual Citizens, the Legal and Cultural Regulation of Sex and Belongings. Her publications include the co-authored Bad Attitudes on Trial, Pornography, Feminism, and the Butler Decision, and Censorship and the Arts. Then after Brenda, we will have Farnush Ghadery, who is a PhD candidate at the Dixon Poon School of Law, King's College, London. Farnush's PhD project focuses on women's rights and women's participation in the context of transitional justice and peace-building processes in post-conflict states, and analyzes the international framework set up for these purposes by the United Nations, namely the Women, Peace and Security Agenda. The research particularly considers the relationship of the United Nations with local women's civil society, NGOs and grassroots movements in such post-conflict state, and focuses especially on the case study of Afghanistan in that regard. Farnush is a Royster Fellow of King's College London and the University of North Carolina Chapel Hill Partnership, and she has been a participant of the Transnational Law Summer Institute 2017 at the University of New South Wales. She has also visited at several other places. And then followed by Farnush, we will have Teri McMurtry Chubb, who is currently a distinguished visiting professor of law at the University of Illinois, Chicago, John Marshall School of Law. On leave from Mercer University School of Law, where she researches, teaches, and writes in the areas of critical rhetoric, discourse, and genre analysis, and legal history. She has lectured nationally on structural discrimination in educational institutions and the workplace, and is a leader in designing curricula to facilitate diversity, equity, and inclusion efforts. Prior to her career in the academy, Teri McMurtry Chubb was a civil litigation associate at a mid-sized law firm in Des Moines, Iowa. And at the time that she joined the firm, she was the first person of color ever to be hired there, and one of 2 African-American women in the entire state of Iowa in private practice. And that was just recently. We are not talking about a century ago. Her law review articles include The Rhetoric of Race, Redemption and Will Contests, and others. Teri McMurtry Chubb is the author of the book, Legal Writing in the Disciplines, A Guide to Legal Writing Mastery, and is a contributor to Feminist Judgments, Rewritten Opinions of the United States Supreme Court. And then the final speaker will be Ruthann Robson, who is a professor of law and university distinguished professor at the City University of New York School of Law in the fields of constitutional law and sexuality and the law. Her legal books include the case book, First Amendment, Cases, Controversies, and Contexts, Dressing Constitutionally, Hierarchy, Sexuality, and Democracy, Sappho Goes to Law School, and Lesbian Outlaw. She has also edited the 3-volume set, Sexuality and Law. Ruthann is the co-editor of the Constitutional Law's Professor's Blog and a frequent commentator on constitutional and sexuality issues. She is also one of the 26 law professors featured in What the Best Law Professors Do. She's also written essays, novels, and a poetry collection. So as you can see, we have speakers from New York, Chicago, London, and Toronto, and this promises to be a very rich discussion. Julie Suk. Julie, I'm handing it over to you.
Yes, thank you. Thank you so much, Penny, for conceiving of this excellent panel, inviting me to moderate it. I'm delighted to be here to moderate the session titled MeToo, the Narrative of Resistance Meets the Rule of Law. We have a fantastic panel of speakers who are doing interdisciplinary scholarship at the intersection of socio-legal history and contemporary law and politics. So we're going to begin in the conversation with feminist theory in all its diversity, with presentations by Brenda Cossman and Farnush Ghadery. And then we're going to move on to thinking about intersectional analysis, its potential and its limits in illuminating the race, class, and gender dynamics of the issues raised by MeToo. And then finally, we'll land on contemporary politics, including allegations against the President of the United States by Ruthann Robson. So some of the themes and questions
before
that we
may continue
together. Yes, some of the themes and questions we may consider together include the rise of the MeToo movement in recent years and its relationship to earlier MeToo movements begun by African-American activist Tarana Burke and other movements such as Black Lives Matter. We're also going to be looking at the relationship of social movements to law, specifically how some of these movements highlight the limits of existing law to address sexual harassment and gender violence. We will raise questions like how the law might provide new solutions to problems articulated by these social movements, and how the MeToo movement is positioned in relationship to the concept of the rule of law. Specifically, on the one hand, the MeToo movement has embraced the rule of law by calling out the abuses of power through which toxic masculinity manifests itself, failures to prosecute and investigate, confidential settlements, non-disclosure agreements, and the like. On the other hand, the MeToo movement is sometimes perceived to be a threat to the rule of law because of its effects, real or perceived, on due process rights of those accused of sexual violence. So moving beyond, the speakers will also think about what it might mean to move beyond existing legal paradigms, including criminal law or anti-discrimination law, to address some of the race, gender, and class power dynamics exposed by movements like MeToo and Black Lives Matter. So with that, I'm going to hand it over to Brenda.
Okay, and I'm going to try to get my PowerPoint on. Okay, the PowerPoint is on, yes? So first, let me just thank Penny and Law and Society for actually making this panel and this conference happen against all odds of the current moment. So my talk today is about Me Too, Sex Wars 2.0, and the regulation of sexual harm, which is really, my book in 8 minutes. So, setting up the impossible. So I come to Me Too interested in the feminist contestations within it. The debates between and amongst feminists about its strategies, its discourses, and its implications. Me Too had its greatest feminist consensus at its most general iteration. Sexual assault and sexual harassment are bad and pervasive. The more monstrous the behavior was, the greater the consensus. And Harvey Weinstein, seen behind here, really the only way I can actually tolerate his face, could emerge as the consensus villain. But the further Me Too moved away from the archetype of this kind of sexual predator, the more the consensus faded. A few dissenting voices, feminist voices, began to emerge in the fall of 2017, especially in relation to the allegations made against Senator Al Franken. The concerns were something about Me Too going too far, which meant either something about including too much sexual conduct or too little due process, or both. But feminist disagreement would explode with the publication of the Aziz Ansari story in babe.net. It told the story of Grace, a 20-something woman, on a date with Ansari, where he repeatedly initiated sex, despite her request to slow down. She leaves in tears and comes to understand her experience as an assault. The feminist public sphere exploded. It was a story that resonated with many women, while other feminists denounced it as trivializing Me Too. It was a debate that was very quickly framed as a generational one, that positioned millennial feminists against second wave feminists. And it turned nasty very quickly. One of the more notorious exchanges was when Katie Way, the author of the Aziz Ansari story, famously called CNN anchor Ashley Banfield a burgundy lipstick, bad highlights, second wave feminist has-been. And I have to say, before that, I didn't realize that burgundy lipstick was over. But that aside, now I have entered into the debate thinking that this generational narrative is neither accurate nor explanatory of the underlying disagreements between and amongst feminists. I argue instead that the feminist debates are actually a part of a long history of feminist disagreement over sexuality that goes back to the sex wars of the 1970s and the 1980s and are being repeated in what I call Sex Wars 2.0, being played out today largely in relation to sexual assault and sexual harassment. So the sex wars were a disagreement over sexuality, agency, and the role of law, particularly at the time in relation to pornography. Keeping in mind the 8-minute simplification, on one side, there was radical feminists who saw sexuality as a site of danger, which limited the possibility of women's agency and consent, and who turned to law to redress the problem. The other side, the sex radicals saw sexuality as also a site of pleasure, women as sexual agents, or at least not entirely victims, and was deeply skeptical of the role of law. Now, in its current version, the 2.0 version, one side, we have the inheritors of the radical feminist position, who push for stronger laws against sexual violence, including broader definitions, better enforcement, and harsher penalties. On the other side are a group that are wary about overly broad definitions, as well as the overreach of criminal and civil remedies, and the underreach of due process protections. Now, these very principled disagreements underlie what I argue underlie the disagreement within MeToo. I try to show in much more detail than I can do here today the ways in which these disagreements about sexuality, agency, and the law play out within the context of MeToo. So in terms of sexuality, the MeToo feminists are effectively the intellectual inheritors of radical feminism, who see sexuality as a site of danger, demonstrating the pervasiveness of sexual danger in women's lives, whereas the feminist critics, the intellectual inheritors of sex radical feminism, push back at this and want to keep space for sexual desire and the ambivalences of sexual attraction. In terms of agency and consent, we similarly see, I think, MeToo feminism seeking a broader understanding of consent, or more specifically, the lack thereof, and the feminist critics insisting on the possibility of women's agency, the idea that women can and do negotiate sexual relationships all the time. Now, this is not an either or here. It really is, I think, a matter of emphasis between the two sides, although that matter of emphasis and the nuances are often lost in what we see in the debates around a kind of reductive caricaturing and often a name calling. Now, I'm particularly interested in the role of law in the current feminist MeToo debates. These debates don't map quite as readily onto the more or less law dichotomy that we see, I think, in the earlier sex wars and, in fact, the later sex wars. MeToo did not emerge as a movement with a legal agenda. It was really much more a performance of law's rather spectacular failure. And yet I think law casts a long shadow over MeToo. In a nutshell, MeToo challenges the centrality of law as the exclusive arbiter of sexual violence. That is, law has always had the power to both define what the harm is and to decide whether it exists on a case-by-case basis. The feminist critics worry about the potential abuses of this challenge. And I think we can see these debates play out in a number of spheres, particularly in controversies over sexual misconduct and due process. I'll say just a couple of words about how it plays out in the context of sexual misconduct. So MeToo feminists talk about sexual misconduct and seek to talk about sexual misconduct, the likes of Aziz Ansari, and the critics see this as evidence of MeToo going too far, because this is just not something that is currently illegal. So I think that their critique makes sense if we think that the criminal law or law more generally should occupy the field of sexual harm. The conduct is not illegal, therefore it's not a sexual harm. But many MeToo feminists, and on the screen you see some quotes from Jessica Valente, are not arguing it should be actionable, but it's still worth discussing as a sexual harm. The problem is that is very hard to hear precisely because of the power of law. It sounds like any attempt to talk about sexual harm then is being interpreted as actually supporting an expansion of the law. So it becomes a very difficult thing to hear. Now, my mapping and highlighting of the various feminist investments and stakes is ultimately with a view to how it could be otherwise. How could we approach the regulation of sexual harm differently, taking the harms that each side identifies seriously? And here I use the work of Eve Sedgwick, which I obviously can't go into in my remaining 30 seconds, to read the claims beside each other as opposed to against, or more simplistically, I think, the bunny and the duck. The power of the bunny and the duck for me is that you can only see one at a time, but you always know that the other one is always present. So I am really interested in trying to develop an approach to legal regulation, to imagine how we might think about and regulate sexual harms differently. A lot of feminist folks are thinking about restorative justice right now. I'm trying to think about reparative justice. I don't even know how to turn this off, which tells me that I'm up. And I'm trying to think here then about a mode of regulation that's not based on retribution, punishment, or incarceration, but accountability and responsibility. And trying to think about new modalities of regulation that can recognize the complexities of harm, agency, and the limitations of the tool that we work with, law. And for me, the spirit of the bunny and the duck helps me do this by trying to hold two very different sets of claims in view at the same time, by recognizing the two sets of claims at the same time. So I will stop there.
Thank you so much, Brenda. Now let's hand it over to Farnush.
Have we got Farnush here? Why don't we move on to Teri, and I'll try and get Farnush back.
Great.
Hello,
Teri.
can you hear me?
Yes, I can now.
Can you hear
I
me?
can't
Teri?
see you though. Oh, there you are.
Okay.
Oh, wait.
Hello, everyone. Thank you, Penny. Oh. Yes, still audio?
We can hear you.
Okay. Thanks, everyone. Thanks, Penny, so much for this organizing this panel. Thank you, Julie, for getting us all together, and thanks to LSA. I enter this conversation at the point of the Kavanaugh hearing because I think that that particular moment in our history highlights the cracks in how we talk about intersectionality and feminism. As an aside, I was on the team who drafted the women law professor letter opposing the Kavanaugh confirmation. And it was a rather multicultural group of women, a mixed group of law professors, clinical legal writing, and those non-skills faculty. That process, our interactions are also relevant to this discussion, and we can talk about that if there's interest, but I want to move on to my remarks. So the way that the media discussed Christine Blasey Ford and Anita Hill often resorted to tropes about how these women were written and discussed. And when I talk about intersectionality during my remarks, I'm talking about how we're using intersectionality in casual discourse. So basically these tropes were snapshots trying to capture how white supremacy, patriarchy, and capitalism played out in the lives of Blasey Ford and Hill, and in the lives of white, Black, Asian, Latinx women, and white and Black men impacted by Weinstein, Cosby, and a host of other public ne'er-do-well figures. These tropes revealed the way we talk about intersecting oppressions, has also become tropish and, in my opinion, downright hegemonic. Blasey Ford was portrayed as a privileged white woman in contrast to Anita Hill's experience in the Senate confirmation hearings, versus looking at Christine Blasey Ford as a sexual assault survivor in a room of powerful men who were bent on and could very well destroy her life. White supremacy, patriarchy, and capitalism were present, but intersected differently for her, but no less to her detriment. How we presently talk about intersectionality, how we throw around the terms casually, suggests several assumptions. First, intersectionality assumes monolithic experiences of women of color. The assumption, for instance, that if you center Black women, everyone else is automatically included. My question would be, which Black women are you centering? Intersectionality also assumes that only non-white women, maybe grudgingly men of color also, face marginalization, impactful marginalizations. Again, white supremacy, patriarchy, and capitalism are present, but intersected differently for them too, but no less to their detriment. The other assumption, and perhaps the most damaging one, and this is part of a larger work that I've done, an article that I wrote, that everyone, including white people, have a race, class, and gender. But the way we talk about intersectionality, especially in the context of MeToo, silences whiteness. And so again, it doesn't look at whiteness as a racial category. And white people have a race, class, and gender. These, being white, bears the histories that are shaped contextually by white supremacy, capitalism, and patriarchy. And these experiences are not historically monolithic. So the way that these identities intersect, the way that these power structures intersect are not the same. And so by silencing whiteness, by not talking about it, again, in the way we talk about intersectionality, that centers the experiences of a perceived group of people who can only be marginalized, elevates it to hegemonic discourse. And then lastly, ultimately, we must talk about the thing we're not talking about. I think we're not talking about. that we're not talking about, excuse me. The way that we have talked about intersectionality in the context of Me Too, we're not confronting what we're really talking about, which is white supremacy, patriarchy, capitalism, and imperialism as interlocking oppressions and how they intersect in the lived experiences of men and women. Instead, what we've done is we've lapsed into a neat little package that obfuscates whiteness and makes the experiences of women of color monolithic. So far as it has become a trite catchphrase in our political and legal discourse, the term intersectionality or intersectional feminism can't do that heavy lifting. It can't do that work, and it doesn't do that work. So I hear students throwing around these terms, and in doing so, they're not confronting their own lived experiences with white supremacy, patriarchy, capitalism, and imperialism in the same way that the media and our social movements are not confronting those interlocking oppressions. So I'll stop there.
Great, thank you so much, Teri. Now we'll hear from Farnush.
Hello, everyone. Thank you so much for having me. I just get my PowerPoint up because I also would like to share my screen. Share.
Can you try share screen? Did you?
Yes, it's just loading. This is weird.
Let's see.
It should work.
Steve, Johar. Oh, there it goes.
There we go. Okay, sorry about that. Right, so my small 8-minute presentation is based on a paper I wrote roughly a year after #MeToo, the viral movement took place. And what I tried to do is look at its origins and reflect on the developments that we saw in that year afterwards in order to kind of find its place within feminist movements and feminist theory, because there was a lot of different kind of voices that then came and said, oh, is this finally the global sisterhood getting together? Or is this, just another product of neoliberal feminism? So I tried to figure out what are these different kind of camps saying, and where would I categorize it as a social movement within feminism? And so I'm going to just dive straight into this, into something that's really significant for my paper, and that's the kind of global reach that we saw with not only the #MeToo, but also the kind of different variations that we saw as to translations, right? So Yo Tambien, Ana Kaman in the kind of Arabic world, and as I come back to it, also variations such as #MosqueMeToo, #Kutu, and the rest of it. And so I'm going to start with this idea that was first expressed by Catherine Rottenberg, and whether #MeToo is just another product of neoliberal feminism. Now, neoliberal feminism is not the most common kind of feminism that we would kind of refer to or teach even within our classes or research on, but it's kind of it's been developing in the past few years as a result of this extension of neoliberalism really to all these different kind of spheres of our lives beyond the market. And that's where this idea of neoliberalism as a political rationality, as Wendy Brown describes it, really becomes crucial for understanding neoliberal feminism. And it's this idea that we're seeing a kind of shifting of responsibilities within our kind of social sphere specifically, that comes from this neoliberal rationality of the individual carrying a lot of the responsibilities that oftentimes you would see much more be carried by different actors, especially the state. And that comes specifically through when we focus on neoliberal feminism. And neoliberal feminism is this idea that the subject is very much feminist, in the sense that is very much aware of the current inequalities that we see between men and women, but it's at the same time it's very neoliberal, because it kind of pushes away this idea of structural inequalities more than anything else, by placing the responsibility of getting rid of sexist oppression on the individual herself. And it's mostly targeted at women, so on the individual herself, right? So because you need to fully accept responsibility for your own economic success, for your work-life balance, for your well-being, it's very much up to you as a woman to, you know, take that responsibility and change your life in the way that you could get to a more equal status. And so one of the best examples to see that in, and Catherine Rottenberg in her work refers to this, is this kind of lean in phenomenon of Sheryl Sandberg, of course, right? And this idea that if women just lean in more, if they want it more themselves, then they can achieve that. And that's highly problematic because it really goes against the one thing that most feminists and most feminist theories can at least agree on, namely the really crucial significance of structural inequalities in our societies that lead to gendered oppression and sexist oppression. So what does it have to do with Me Too? It's got the relationship to Me Too comes from this idea that, again, came from Catherine Rottenberg, that does this me within the Me Too, this individualization of the person, of having to come forward, of having that responsibility to step forward, to say, this is, I also went through this, and you know, to make their voice heard, is that indicative of #MeToo essentially being another product of neoliberal feminism? Also because the format of it, the way it has been done, whether that is, you know, the kind of idea of hashtags, or whether that is the idea of actually wanting to step forward to change something, leads to exclusions of certain voices. Right. So that kind of line was drawn, and the question arose. I thought about that a lot. I also teach the session, and I discuss this a lot with my students, who are all of this #feminism generation, essentially. And I thought it was really interesting to look at the symbolism of the hashtag for digital activism and the use of hashtag within feminist activism. So Me Too was not the first time we see feminist activism take place in a hashtag form, right? So we've seen hashtag everyday sexism by Laura Bates, it's still ongoing. Yes, All Women was a hashtag that took place in the US. Been raped, never reported was a hashtag that's still ongoing with different kind of projects, even on Instagram besides Twitter. So we see this was not the first time that a hashtag had been used for the kind of feminist, for a feminist kind of goal as such, right? And so I focused on the role of #feminism within digital activist movements. And what becomes quite clear is that essentially what it's being used for, the hashtag, is another kind of consciousness raising endeavor, right? Yes, it might be that it is oftentimes combined of individual stories, but those individual stories, especially through the hashtag, lead to having a certain kind of collective. And that collective can be very powerful for these kind of social movements in raising awareness and consciousness raising as a kind of method, or even as a kind of activist tool, is obviously very much at the heart of feminist movements. So I thought it wasn't fair to describe #MeToo as just another neoliberal feminist product, purely because it really was able to grab that, to use that hashtag as a consciousness raising tool, and really raise consciousness like we haven't really seen in a very long time for an issue around the world. So moving on to that around the world, I then considered different kind of voices that came along and said, this is it, finally now, you know, we've been waiting for this, sisterhood is now global. Obviously, the sisterhood is global relates back to this idea of global feminism as it arose decades ago, and faced quite a lot of backlash naturally as a result of its very much universalizing language and discourse when it came to women's different experiences, women's different identities that were then disregarded. I'm not going to dive into that, but then the question arose, is that really something that is then fair to compare it Me Too to? Because we do see that exclusion, right? I'm not going to go into the many kind of pitfalls and shortcomings of the Me Too movement with regards to exclusions, because they do exist, right? One of them is the exclusion of LGBTQ plus, the LGBTQ plus community at the very beginning. It started also off as a very white elite kind of movement, but at least the viral kind of hashtag #MeToo. So it does have many of these shortcomings that the kind of global feminist movement was, was accused of as well. But again, that wasn't really enough for me because, and I'll give a few examples of why I felt like that was not being very, that it wasn't being really fair on the movement as we saw it develop over the few months after the one tweet by Alyssa Milano. And that goes back to the global reach of this movement again. And not just the global reach as in, oh, we see translations, we see #MeToo being used in different kind of places around the world, but the way that the hashtag and the momentum the hashtag came with was really being used by individual communities around the world to contextualize it with regards to their own issues and their kind of depending on their own identities. So I'll give a few examples of what I mean and why I think this is then a sign of a much more transnational feminist movement rather than one that can be reduced to the global sisterhood rhetoric. But before that, just a real quick, what I tried to say by transnational feminist movement, very much this idea on focusing of how we understand the production and reception of diverse feminisms within a framework of, for us, transnational social movements, right? So this diversity and this understanding and this respect for intersectionality that the global feminist movement was accused of not having and clearly was not having, that I think we can't really say #MeToo 100% suffered from as well. And the reason why I say that is that are these different kinds of hashtags that then arose out of the #MeToo movement that very much took this hashtag and contextualized it to the individual communities that were concerned. And I want to give an example here of the hashtag #MosqueMeToo that started with Mona El-Tahawi reading a Facebook post by a woman writing about her experience of sexual harassment during the Hajj. And so hashtag #MosqueMeToo then really went viral amongst Muslim communities who wanted to raise consciousness about their experience of sexual harassment and abuse during religious pilgrimages, but also at religious sites and the rest of it, right? So we see this, we see #MeToo being used in order to draw attention to a specific issue of this community, and it did so quite successfully. We then saw it with hashtag #MeQueer almost a year ago after hashtag #MeToo. Again, it started with a tweet in Germany and then went viral with, drawing attention to the specific kind of experiences of the LGBTQ plus community. And again, these are just a few examples. There's many more. This is, we see the hashtag #Kutu in Japan that was used to draw attention to women having to wear high heels at work. Again, went viral. We read it all in our newspapers and was quite successful. So I draw back to this question: how do we understand the production and reception of diverse feminisms within a framework of transnational social movements for our purposes? And I think these different kind of manifestations of the hashtag #MeToo movement demonstrate how I personally don't think it's right to kind of just reduce it to the same shortcomings of the global sisterhood kind of movement, because it does lend itself to, or it has lent itself to this more contextualized approach of allowing those communities to use it for their own kind of specific identities and the issues that they face. Yeah, so that was all very quickly in my 8 minutes. I hope I didn't go over, and thank you so much.
Thank you so much, Farnush. And now we'll hear from Ruthann Robson.
Thank you all, and thank you for is my screen share?
No, not yet. There we go.
Now? Okay,
Yep.
sorry. So mine is actually more narrow, and it really focuses on Trump. And it comes from really a place where reading so much of what was happening and not really being able to keep it all in my own head at once. And I really looked at two things, and I'm only going to talk about one today. But one thing I talked about was, or kind of tried to explore, was almost a counterfactual. Where is sex in the Mueller report? And the answer is nowhere, except in these very like caged footnotes, which you had to already know what was happening in order to understand it. And rereading the Starr report about Clinton, which everyone described as salacious and still is, and really kind of thinking about why is one way and why is one a different way. But I wanted to talk today looking at the kind of sexual misconduct, mostly in terms of non-consensual. And what do we do with all of this is really my question, right? Like, how did we get to it? So my idea really is some sort of commission. And when I first started writing this, I had kind of more grandiose ideas, like a Watergate commission or 9/11 report. And now I think there is so much that would have to be in any kind of commission post-Trump. And that's, I think, one of the good things about my project. It made me think about a post-Trump world. And I've come up with a more modest idea, really just a kind of DOJ or congressional commission. And what would that look like, right? What might happen? So first, really starting off with who are the women involved in all of this, or who are mentioned, and like kind of where are they? So the people in the larger type are people who have actually litigated. The Summer Zervos is still going on, and that is about defamation. E.G. and Carroll is about defamation and assault. Ivana Trump, who was his first wife, there was a rape case in a domestic case. Jill Harth, who we don't hear about too much, who litigated against him, and that was settled. Alva Johnson, who in all of this is the only woman of color, pretty much only woman of color, African-American woman who is a campaign worker who sued. And Title VII didn't apply, the court said, because it was a campaign. She was a campaign worker, and it's not work. And I'll get back to some of those issues. And also that it wasn't assault because it was 8 seconds. And Jane Doe, who was a minor. Now, who are all these other people? And one of the reasons I wrote this was that I couldn't think of them or kind of keep them straight in my own mind. So there were women that did not know Trump before, right? So woman in a, sitting next to him in an airplane, woman outside of a stadium, you know, those sorts of things where just a kind of random assault by a man that you don't even know, those things. Women who had some kind of employment with him or some kind of social interaction. Kathy Heller is someone who was just at a brunch with him. And then the people in the last group were also non-workers, but were in some kind of working relationship. Some of them are, you know, Miss Utah, Miss Norway, and those kinds of incidents where there's either some kind of direct assault or some definitely unwanted sexual act. So the civil remedies really have not been helpful, right? So sexual harassment, most of the time these people are not in an employment relationship, and Trump is not in an employment relationship with him. And even the campaign worker, they said Title VII doesn't apply. Assault and battery hasn't been helpful. And even if those were good actions, statute of limitations, the one that's really emerged has been defamation. And so that when people have said something and said yes and come forward, and some of them came forward in part because they heard him saying, no, I am not that kind of person. I would never do that. And they said, like, well, you did it to me. And then he would say, no, I didn't, or I never heard of you, or no, none of that happened. And so those cases are going forward, or there are a few of those. And the question really is he immune from suit? And a famous United States Supreme Court case, Clinton v. Jones, and yes, it is that Clinton and that Jones. And the question is that applicable in state court? And New York's highest court is trying to decide that now. But all of this, what comes down to is that the civil remedies haven't really been very robust or helpful for a variety of reasons. So that's really the genesis for what about a commission that would have hearings that would talk about and allow people to testify as to their experiences. Here are the advantages, I think. So one advantage is that we really get to, or we could possibly get to, hear about the women. Can we move them from just media or in some cases lawsuits, objects to subjects? And here in thinking about all of these women, I saw that they were both under-individualized and over-individualized. I think this goes to something that Farnush was saying as well, right? That we think of them in a very particular way. And so they all kind of blur together, for one thing, right? We can't, who was the porn star? Who was this person? Who was that person, right? And the other thing is that they really became one-dimensional. And he was very big on saying, never heard of her, or other people in his stead would say, never heard of her. And the example here that I want to bring forward is this woman called Nancy O'Dell, who most of us had never heard of. But she's the woman who, in the Access Hollywood tape, Trump is referring to and saying, oh, and I even promised to take her furniture shopping. And I, for one, when I heard that, I thought that was like the stupidest thing I'd ever heard, right? Like, that makes no sense to me. But when you think of Nancy O'Dell as an individual, here is a woman who was wanting to start an interior design business, was doing things like that, and thought at one point maybe he could help her, right? So she's trying to situate herself into a business, and that's why there's the whole furniture shopping thing. On the flip side of that, everyone becomes over-individualized and over-determined, right? Why didn't the woman, and this is so typical of me too, right? Why didn't the woman do this in this situation? And it also points to that the tort claims, and even to many extent the sexual harassment claims, are really seen as individual harms, right? And we can't get at the overarching patriarchy situations that allow this to happen. The other thing was, I thought that a commission and hearing from women, right, could dismantle some of the strategies of silencing. Because one of the things that one really sees in the Trump situation is how women are silenced. So the non-disclosure agreements are really the big and most legal method of silencing. But another thing was very much like an isolation. No, you're the only person who's ever complained about that. No, no one ever thinks of that. No, don't tell me, or don't tell anyone else that. And then in some cases, the outright threats, right? We could ruin your career. We could do other sorts of things, and having kind of, and Michael Cohen was a good person who was the, not a good person, he was a good person who did this in terms of, you know, I will make you pay for this. So what possibly could a commission come out with in terms of legal remedies? Well, they could come up with some recommendations about non-disclosure agreements, and maybe even some laws in terms of, if you're a public official, can you enter into these? And if you become a public official, are previous ones that you've entered into now void? Amendments to Title VII and other kinds of workplace statutes, how do we think about that? Congress could actually do something about presidential immunity. They could certainly do something about some of the, at least the federal rules of evidence. And that's kind of a technical thing that I don't want to get into too much, but about what kinds of, or when would evidence of all the other people that experience the same thing from this person, right? When that could come in. And some judicial education. So in the Johnson case, what the judge writes, I mean, I just think is completely appalling. And then you could have some state law recommendations, statute of limitations, defamation, tort remedies. And there's a larger discussion here about defamation and how Trump has used that and how it's been used against him, and all of that, which I go into the article. And then finally, I do think that there is some educational and cultural effect of those kinds of hearings. And I think what, you know, what Brenda was saying in terms of, you know, what would we look at, you know, what is the discourse? How can we go to some place of accountability and responsibility, maybe that doesn't have particular legal remedies? What would that mean? And the flip side of that question really is, what does it mean to women now that all of this has happened and people have sort of shrugged and it hasn't been really part of any kind of MeToo backlash? Thank you.
Thank you so much to all the speakers. So I wanted to maybe raise a few questions and have a conversation with the speakers, and then open it up to some of the wonderful questions that we're receiving from the audience. So one theme that ran through all of the presentations was the relationship between individual claims, or the individual victim at the center of the movement, perhaps encapsulated in the word me. And then, of course, the collective, the idea that this is actually not about individual claims. It's about structural inequality. It's about systems and infrastructures. It's about global capitalism perpetuating a certain political economy of misogyny or toxic masculinity. And I was really struck both by the image of the duck and the bunny that Brenda put up on one of her slides, and this question, too little law or too much law? Or the wrong kind of law, I guess might be another way to put it, as we think about the relationship between individual claims and all the legal tools that we have around individual claims, including things like Title VII on sexual harassment, doctrines of immunity or not immunity around the president on the one hand, versus what kinds of collective action or structural intervention can be seen as a way forward from these movements. So I guess I'd like to maybe open that set of questions up to all of the speakers and maybe invite any of you to comment before we open it up to the remaining questions.
Why don't we start with you, Brenda?
Thanks, Penny. So I do not have an answer to, these are the $64,000 questions. I really loved Ruthann's discussion of the idea of commissions, precisely because it is a move away from, because I really feel that we are often locked in a kind of feminist carceral logic around the only way to really take a harm seriously is to criminalize it or to do something that is criminal-like. So even the civil remedies are kind of have a carceral logic to them of we need to punish people. It's, and we know all the problems of things that are deeply individualized. And I think we also know the problems are very well rehearsed around the problem of a carceral state. So I love the idea of trying to think about different modes of collective action. And so, the idea of a commission, I think, is actually, it's quite brilliant. And of course, it's also, very much, it's rooted in the post-apartheid South African movement of trying to, to think what does restorative justice, what is transitional, what does transformational justice look like, that really gets us outside of this really individualized way of thinking. And yet, of course, those of us who are lawyers, we have a toolbox and we go to the toolbox, and the toolbox is deeply individualized. So, I'm trying to think about how do we move away from that.
Farnush or Teri?
So this whole kind of connection between the individual and the collective is something that really drove me into, figuring out whether this can be, but this is really one of the shortcomings of the MeToo movement, where you can say this is just, again, neoliberal feminism that we see again and again and again. It's really just such a problematic kind of way of I struggle even saying neoliberal feminism, because I don't think this should even be described as a kind of feminism. So I thought about that a lot. And for me, this individual notion of using the hashtag to also say your story, or not say your story, right? You could have just said hashtag MeToo as well. It was essentially just a novel kind of, or a digitized kind of protest movement, right? In any kind of protest movement, if you want to partake, you still have to go out on the street. Okay, so, and that is the normal way, or the old school way of what we would describe it as. And we now see that take place in a digital form. And I do think that's necessary. We do need the collective for a consciousness raising campaign. And I think over, more than anything else, that's what it was. And that's what, individuals who partook in it used it as, right? I don't think that I don't think that individuals who wrote the hashtag in whatever form it came thought that their case would be picked up and then, prosecuted or anything like that. It was about showing the kind of collective movement that stood behind it in order to show what big of a problem it really is, right? And that's because, as Ruthann has also said, the enormous silencing that happens with sexual harassment. And you see so many of those tweets and Facebook posts and whatever saying, I've never spoken about this before. This is the first time I'm coming forward. And so I do think it's that collective element behind it is incredibly important still as well.
Teri, did you have anything to say?
Not really. I just, I was thinking about the inadequacy of anti-discrimination law in the employment context through Title VII, and how it very much capitalized. I mean, if we're going to put it in the context of Me Too, how the way that jurisprudence has evolved around Title VII is very much about the me and not about the structural issues. So like we're still, when we're litigating these types of cases, looking at, will a court even recognize multiple intersecting identities? And we're not even able to get to, the white supremacy, patriarchal, capitalist underpinnings of what we're actually talking about. So I think there's this tension where, as Farnush said, there's this tremendous power in the collective of all the sum total of the stories, the weightiness of the sum total of the stories. but either the individual gets subsumed in the collective or the individual becomes the proxy for the collective. Both things can be very problematic.
Ruthann?
So I guess for me, one thing in this really is a question that I have, and that's the not individualizing the person who's claiming the Me Too, but the harasser, predator, right? Like at what point, and sort of the not all men kind of hashtag, right? So, and Trump is a very good indication of that, or personification of that. Is that the way all men act? And I guess that's really the question that many people still have. And I guess I would say, and I am not the best person to say how men act. Don't be laughing, Ms. Andrews. But from my limited experience, I mean, I had a father, no, they don't act like that. And so what is the, how can we think about that or deal with that as well?
So I wonder if a framing then might be, we don't know if that's how all men act, or, but the idea that they could, right? And so it's what kinds of structures and frameworks do we create in which people are able to use discretion or what power they have to act in certain ways. I mean, in some ways, that's what so much of this is about in the context of sexual harassment. It's really not just about the sex, but about an abuse of power, that someone holds a position of power and they have a choice to make in terms of how it's wielded. And I wondered if we could think about it as not just an on-off switch, like men act this way and then the carceral logic comes in. Then we have a whole bunch of legal tools to determine whether or not someone has crossed a line that we know where to draw, as opposed to thinking about a bunch of enabling levers that people can abuse when given the discretion. And once we take that approach, how might our legal tools change or look different? And I also want to second what Brenda said about the commission idea, which I think takes a different approach than the tools with which we're familiar. And I would thank Ruthann for bringing that up. I was wondering if the panelists had questions for each other, and then
can I just also interject you, Julie, if you don't mind? We've got 10
Of
questions
course.
in the Q&A. So I think it would be the panelists, if they could just maybe suspend their questions for each other. And if you could just take a look at the Q&A, and if each of you could choose, because you all have questions addressed to you, and Julie, you may also be one to weigh in if you think it's appropriate. But I wonder if you could go to the Q&A and choose one question addressed to you, each of the panelists, and hopefully we'll be able to get through all 10 questions. Does that work for you, Julie?
Sure.
Yeah. So Brenda, why don't we, because the first question came to you from Monica Williams. Why don't you take one question and then we'll move, then the next person, Teri, then Farnush, then Ruthann, and then we'll go back to you again, Brenda. So choose one of the questions. I see the first question from Monica Williams is for you.
So I'm going to jump to another question, which was the one about the Department of Education's final Title IX regulations will allow higher education institutions to use ADR.
Okay.
And do I think that's a good thing? So on the one hand, I have to say, far be it from me to ever agree with anything that has ever come out of Betsy DeVos's mouth. However, I do think that there is a lot of space to experiment and explore and imagine the role of consensual dispute resolution dealing with a broad range of issues, including sexual harassment and sexual misconduct. Now, this is particularly in relation to Title IX. There's many other ways we could also think about using it, whether it's Title VII, whether it's, you know, outside in Canada. There's been some considerable use of it with campus sexual violence, particularly in relation to a case that happened in Dalhousie that has become quite famous. Now, I think that there actually is a lot of space here. And one of my doctoral students is currently writing, in fact, a dissertation on consensual dispute resolution and sexual violence on college and university campuses. And I come back to the problem about somehow I think people oppose this thinking that it's not as good as the real thing, right? It's not as good as punishing someone. Somehow it's like, it's not taking sexual violence as seriously. And I think that that is, again, how we're locked into this kind of carceral thinking about punishment and retribution. And I think that, you know, one of the things that we're seeing and learning about restorative justice projects, and of course, they're, you know, they're all over the map. There's so many different kinds of this that it's hard to even, you know, hold on to what that necessarily means. But a lot of folks who go into it, who go into a restorative justice process, come out feeling better. Now, very few people who go into, you know, a Title IX scenario or a criminal scenario actually come out feeling better. Nobody, you know, nobody goes into law and actually comes out feeling better. It's about, you know, how awful do people feel on a scale of 1 to 10. But, you know, nobody comes out of like a criminal trial going, God, that was awesome. Whereas restorative processes, actually sometimes people feel, and there's no guarantee that this will always happen, but there is a possibility of accountability. There's a possibility of responsibility. There's a possibility of being heard. There's a possibility of not being gaslighted. And I think that many victims or survivors, that's actually what they want, is to not be gaslighted. And one of the problems with adversarial processes is that it is, by its very nature, is going to be a process of gaslighting and not listening. And so I think that there is wonderful potential. I think, you know, there's a lot of ways that restorative justice could go off the rails. It needs to be done properly. We need to figure out even what we mean by that. But I do think that it is potentially a step in the right direction.
Thank you. Teri, do you want to grab a question? In the Q&A. Do you want me to read the question to you, Teri? Or can you see it?
You're on mute.
You're on mute. Teri, there's a question from Alicia Shivji. Can you see it?
Yes, I can see it. Yes, I'll take that one. Sorry. I had my screen up and it wouldn't let me unmute.
Thank you. How can we move discussion?
Yes, so Alicia's question. So I'll get there by 2 examples. One, I was invited to a class on prison narratives to talk about policing Black women in particular. So I thought I was going to talk about, you know, I thought I was going to have a resistance about talking about policing Black women as opposed to how we're centering Black men in the discussion of Black Lives Matter. Somewhat. But what happened is that I started talking and I threw out the term rape culture. And so I had, you know, this is a class of undergraduates and they're, you know, 18, 19, 20-year-olds. And so I had like a 19 or 20-year-old white guy kind of tentatively raise his hand. And he says, I'm sorry, because I told him to interrupt me anytime. And he said, I'm sorry, I don't know what rape culture is. To which most of the women in the class started laughing hysterically about him not understanding what rape culture was. So we had this discussion about rape culture, which was very illuminating. And, you know, it was like, I didn't expect there to be this like really dynamic exchange among the class members about rape culture and how they had experienced it on campus. And so at that point, a lot of the men in the class, and it was a mixed group, primarily white and Black men, as far as the male participants in the class, began to have a really like open discussion about how they had participated in rape culture and they hadn't known it. So if they were participating in street harassment and they didn't realize that that was not welcome for for women. We did not, automatically be like, oh my gosh, someone's street harassing me. This is wonderful. They didn't believe that they didn't understand that wasn't a welcome thing. So that's one of the things, I think, how we can start to talk about it and surface exactly what it is we're talking about. The other example is there was a specific, so when I was teaching in the South, I had, many of my students noticed that they were rewarded or punished based on how they were living through their various identities. And so in particular with some of my white women students, they would tell me, oh, I didn't get this spot on this team, or I wasn't chosen for this, and this seems a little weird to me. I don't know why. And so we began to talk about it. And so we, looking at what brand of white femininity was rewarded in that context. And it was a very kind of presentation of oneself as being deferential and sweet, and not challenging, that yielded the greatest payoff in terms of like what kinds of things you can get in that structure, how you can move in that structure, how you were selected for jobs. And so by talking about that specifically as this very kind of upper class moneyed white woman experiences, I think opened the door for white women who weren't having that experience to talk about how those things converged to their detriment, how that they weren't participating in patriarchy and white supremacy in quite the same way, and what that meant for their lived experiences. So the bottom line for the question, Aisha, about how do we move beyond the lived experience, this kind of trite discussion about intersectionality, and talk about white supremacy, capitalism, imperialism, and patriarchy as they intersect in the lived experiences of people, that we have to talk about the real lived experiences of people, and how contextually they're given punishments and rewards for how they navigate that particular space. Penny, you're muted. I can't hear you.
Penny, can you unmute?
Yes, I'm sorry. Before Farnush and Ruthann talk, I just want to make a general announcement to the attendees at this webinar. There's about 100 in the room. We chose a webinar format today for the sessions today, but from tomorrow, you will not have to write your Q&A. It will be much more interactive and much more social. So that's just to tell you that we chose the webinar format for today, but for tomorrow, it will be Zoom conferencing and it will be more interactive. All right, so maybe we can move on to Farnush or Ruthann to choose one of the questions from the Q&A.
This is just a reminder, please read the question because it's not visible to all of the the list of questions is not visible to all the attendees. So read the question that you're answering before you address it. Thank you.
Do you want to go, Farnush?
Sure. Sorry, I was just unmuting. Yeah, I'll just, I'm happy to just take the next question after Teri's. And someone asks, Anisur Rahman asks, in Bangladesh, writer and poet Taslima Nasreen has been talking about sexual harassment exploitation in her novel. Could we consider it a movement like MeToo? So obviously this is an individual story that is being shared, but that doesn't mean that that can't then later on lead to a movement. So we've seen that actually happen around the world, and quite often in different countries, where a person who has come forward, they can be a celebrity, not necessarily, you know, Hollywood kind of celeb, but just being known in the country, or it can be that they then later on became known as a result of themselves sharing the story. So a prime example is South Korea, where a prosecutor came forward sharing her story of sexual harassment within the workplace, and that then really kick-started the movement in South Korea around MeToo. And so yeah, an individual story can very much trigger a movement. So you know, there's nothing to say that in Bangladesh that writer's story cannot do the same. Thank you. Ruthann?
So the question I have is really the educational and cultural impact of the Kavanaugh hearings or the impeachment trial versus a commission, given polarization? And would the commission necessarily empower women? So I don't think anything necessarily kind of empowers women, right? And so much would be how it would happen. But I was really struck by the 9/11 Commission, the Watergate Commission, those kinds of commissions where the underlying idea was, this happened, this was bad, we need to do things so that this doesn't happen again. And I think maybe with that framing, and it was something that Brenda was talking about as well, maybe it would have more of a educational impact in the way that the Kavanaugh hearing certainly was educational and cultural, but was very polarized, right? And not just polarized, people were crying, right? Like listening to this. So if we could somehow, and of course, you know, what I'm talking about is some kind of post whatever era we're in, how do we get out of it? And that's kind of trying to think about that.
Thank you. So what I'm going to do is I'm going to read a question from Rachel Van Cleve. It's for the whole panel, and any of you can choose to answer. The question is, I'd love to hear the panelists' thoughts about the value or recognizing the different harms, even if they do not technically fit within any of the quote-unquote legal definitions. My research of survivors of military sexual violence have their harms compounded by the denial of the military that they actually suffered harm and retaliate against those who report. So it's from Rachel Van Cleve, and it's for all the panelists. We want to start. Julie, do you want to say anything? Brenda? Brenda, go ahead.
Oh, I was going to say, Julie, go ahead.
Yeah, Julie.
Julie, you haven't said much, so go ahead, and then I'll say something.
Oh, so, well, I guess I'd like to hear more about the different harms that don't technically fit within any of the legal definitions. I think that earlier Teri was talking about some of the limits of Title VII sexual harassment doctrine. And I think Brenda was talking earlier in the panel about carceral logics. And I think those forms of critique really focus on the problem that the legal definition really emphasizes particular moments that can be proven with certain forms of evidence in an adversarial setting, and that somehow misses out on the totality of power dynamics that the MeToo movement is trying to call out. So my thinking about it is that it's not really the harms, and I almost feel like maybe focusing too much on legally definable injuries compounds the problem, because I think that there are different kinds of harms and, or the kinds of problems that is often, if you look at some of the lawsuits where people are looking for remedies, it's not necessarily traditional remedies that some of the lawsuits growing out of the MeToo movement are looking for. So if you look, for example, there was a lawsuit filed against Yale University because of their failure to manage the sexual dynamics in fraternities. And while some of those, and what was very interesting is that most of the claims were dismissed. The court only allowed the allegations that fit into someone was sexually assaulted in a fraternity and the university failed to do something about it. And those were the only claims that really got recognized. Whereas the groups of women who were bringing these lawsuits were almost less focused on sexual assault. They were more focused on the fact that fraternities were these spaces of power that gave women access. Not only where women were subject to sexual violence, but the exclusion of women from membership actually excluded women from professional networks and other forms of power, social power on campus that then translated into forms of social capital after people graduate from college. And I think if you look at a case like that, it seems like focusing on harm might even be the wrong lens. Focusing on the remedy seems to be more important. The remedy that they were asking for was either abolition or total gender integration of fraternities. And if you look at an example like that, it seems to me that even the relationship between harm and remedy might be the wrong framing. Maybe there has to be a sort of larger scale public policy response that's about restructuring relations of power within organizations. And that restructuring has to be framed differently from the kinds of interventions law provides once an injury has been proven, whether it's in the criminal law context or the civil liability context.
Brenda, thanks. Julie?
That's great. So, you know, I constantly keep coming back to part of the problem here has precisely been law's hegemony over sexual harm. And then the hegemony of carceral logics within law. And I get logics because sometimes it's being brought to bear to the civil context as well. And for me, part of the problem there is also that then an allegation of sexual harm is made, and all of this legal scaffolding comes into play, which by definition then involves denials, complete denials. Why? Because the stakes are also so high. And I just think if we could find other ways to talk about the harms, and other ways to even then think about the potential remedy. So I really appreciate Julie trying to shift the conversation a little bit to remedy. Because it seems to me that traditionally lawyers have had a very narrow concept of what a remedy could be, right? So it's like you put somebody in jail, you issue an injunction, or you do some damages, and you know that's about it. And I think no, really, like there's a lot more things that can be done, which is of course part of what comes into the restorative process as well. But I think if we could think differently about remedies, about kind of therapeutic remedies, about consensual remedies, it could help us move beyond this really sort of narrow way that we have really scaffolded the entire thinking about sexual harm.
Ruthann, you've got your hand up. Thank you, Brenda.
So I guess going back to the military kind of question and other questions about organizations, right? I think that the person doesn't start off thinking of legal remedies or to sue, right? Like they complain to someone or they reveal their story to someone. And I think that that's part of the issue, right? That there is then a sense of betrayal, and that the people I thought supported me, my, other people in the military, my colleagues at school, my colleagues at work, I thought they would take this serious, and even apart from sort of harm, as opposed to then retaliate against me, ghost me, do other kinds of things as if I am the problem. And I think when you read the kind of journeys that people make to decide whether or not even to sue, but decide whether or not to tell anyone or reveal it. I mean, they're very fraught, and they're very worried about, being gaslighted, being denied, but also the betrayal from the people who they thought cared about them.
Mm-hmm. Yes. Teri, did you, or Farnush?
Yeah, I was thinking about the harm and the violence and not recognizing that a harm has actually occurred. So I think for many women in an institutional culture that doesn't recognize what happened to you as a harm, that's another violence, right? And it doesn't get fixed by the complainant process, by litigation, because there's always the recognition that there's a recognition there that you are railing against an institutional machine, but not necessarily a recognition that something happened to you to kind of trigger that particular response. So it's like Ruthann is talking about, that there's kind of this feeling of betrayal among the people who you are complaining from, the person who is actually complaining about having not been listened to, but also the people who are protecting the culture. They feel a sense of betrayal that you have actually said something that highlights a dysfunction in the institution. So I think that, talking about the culture of a place or an institution is helpful in surfacing what are the values and to what extent is an expression that there's a dysfunction in the value in the culture of the institution. What kind of violence that also enacts upon the person who is suffering a harm.
Thank you. Farnush, or shall I go to do you have anything to add?
Yeah, I was just thinking about just a very brief comment on this. What Brenda said, the hegemony of law within sexual harassment is, of course, very evident. And I just think it's very interesting when we look at the results of #MeToo in different countries, that it then oftentimes was throwing more laws into the face of this kind of movement, right? So we're now having laws for catcalling and the rest in different countries, and that seemed to be the response and the solution offered for this movement, when we know that's not going to do anything at the end of the day, right? Because that kind of whole other dimension is missing within our understanding, within our education, and when it comes to sexual harassment.
Thank you. Now we've got 15 minutes left and we've got a few questions, so I'd like to honor those questions. So I'm going to read the questions to individual panelists, and if you answer the question, and maybe we can get through all the questions if that's fine with you, okay? So if you could keep your answers relatively brief, because we have, I think, 6 more questions. So to Brenda, the question from Anne Friedman: I'd like to hear more about reparative justice and how it holds the two perspectives together.
Great. So I have to confess, I do not have this all worked out. I don't have a blueprint yet, although it is the chapter that I'm currently working on. So what I'm trying to think about is a way to break out of the endless sex wars, sort of these endless debates of sexuality is like this or like this, consent is like this or like this, more law, less law, to say both sides, first of all, are actually far more nuanced than you would know by listening to the other side. A lot of what we know about the debates, we know through the caricaturing of the other sides. And I want to try to hold on to the idea that both sides on both sexuality, consent, and law have really important insights. And it isn't a matter of necessarily picking one or the other. So yes, there are real sexual harms. Yes, there are real problems in the way those sexual harms have been written into law that tend towards overly victimizing women, like constituting women as victims. Why can't we find a way to hold on to these two things simultaneously as we try to think about alternative ways of thinking about and regulating and creating remedies for sexual violence? And so, and for me, I always start with, I am not a fan of the criminal law. I think it probably still has some role somewhere. I'm just not sure where it is, and it's not in my areas. And so part of thinking reparatively for me is decentering the criminal law, is decentering the kind of carceral logics, and to try to think about how can we, and again, I feel like both sides are really guilty of this. Like, so how can we hold on to the idea that there are very real harms that come to women and other victims, and law itself produces very real harms. And it ought not to be a matter of choosing between these. It ought to be a matter of thinking differently about how can we try to reduce the harms that law itself creates while finding some redress to the sexual harms that victims and survivors have experienced. And so for me, the idea of the reparative, the idea of reading beside, and this is really what comes from Eve Sedgwick, but it's also the Bunny and the Duck, is this idea of how can we hold both of these claims to be really important at the same time?
Yes, thank you, thank you. Now I'm going to shift a question to Teri. It's from Christine Harrington. It's not directed to you, but it's just to the panelists, but I'm giving it to you. The question is, how about shifting the conversation to the quote unquote process, to the enactment of law?
So I might be misunderstanding the question, but I always get a little nervous when we start talking about process, because for some people, especially in this context, having a good process is a proxy for justice. And that's not that's usually not the case. That if, you know, the sheer act of going through the process is perceived as whatever that process may be, the process of reporting Title IX complaints, or the process of complaining and going through the chain of command, or the process of participating in, you know, a legislative process. Or some people would say that the fact that Christine Blasey Ford got a chance to be heard is enough, right? That was enough. And it's not. It's woefully not enough. But I think there have to be enough people at the table to understand, again, that nuance of, because what I want to say is, I'm trying to be diplomatic here, but I think that the process of even creating a process can do violence depending on how capitalism, white supremacy, even patriarchy and imperialism impact in the very body of the person who's subject to the process, and the people who are enacting the process. So I think we have to have a very nuanced discussion about that. Like, what, you know, if you just look at just the optics of it, right? Like, you have this, just the way even the room is set up. And I'm just flashing back to the Kavanaugh hearings, and you've got, you know, the Senate here, you've got Blasey Ford here, and you've got her attorney here, and, you know, just the visuals, the optics of that. Like, what does that look like? You know, what are we staging here? When I think about hearings that go on a campus, and I think of, you know, you have the person who's complaining about a particular issue in a room, and they may not be able to have representation with them, and they're sitting at a table, and you've got the weight of the university on the other side of the table, and what does this look like? So I just think this goes back to what Brenda and Ruthann and Julie were talking about, in terms of what exactly are we trying to address, and how are we trying to address it, and how are we framing what the actual harm is, and what are the remedies that might be effective.
Thank you, Teri. Farnush, a question from Chia Aiki. I hope I'm pronouncing her name correctly. Do you know of any hashtag MeToo movement focused on armed conflict?
I haven't come across a direct correlation between MeToo and feminist movements within countries that, you know, are currently in conflict periods or post-conflict periods. But that's not to say that there's not obviously a lot of feminist movements going on in those countries as well. But I just haven't seen a correlation between the two.
Okay, is anybody want to respond to that? Focusing on MeToo and armed conflict. All right. Then Ruthann, a question for you from Anne Friedman. The educational and cultural impact of, for example, the Kavanaugh hearings versus commission proceedings versus impeachment trial, given the polarization, would the commission empower women?
So that's, I think I tried to answer that before.
All right, then I'm going to give you the question to you from Janet Calvo. I saw a question there from Janet Calvin. Would the commission have to be governmental? Would a commission by an NGO or other civil society entity be effective?
I hadn't really thought of that. I mean, I guess I'm very much in the legal framework, and, you know, quite frankly, for me, it was kind of a stretch to come up with something that wasn't judicial, that was, you know, congressional. So really, I have no idea, but for me, it's hard to imagine something that would have power that people would pay attention to that was outside of government, at least in the United States right now. But certainly there, I don't know, maybe it could be a reality TV show.
All right, thanks, Ruthann. Brenda, I'm going to go to the first question that Monica Williams asked. Can you talk more about the quote-unquote less law perspective of feminist detractors and how it compares to the hashtag MeToo feminists?
So it's a great question, and I don't feel like I was able to really sufficiently tease that out. So I think when we look at what I refer to as the initial sex wars and then the sex wars 2.0, I think we can see a very direct line between the different perspectives on more versus less law. In the first round, it was really all about censorship and non-censorship laws, and the kind of feminist critics, the sex radicals, were very anti-regulatory. Their impulse was very anti-regulatory, and the other feminists were very regulatory. Fast forward to the debates now, and if you look at the debates, particularly as they've happened around Title IX on college campuses, I think what you see there is debates about, there's clearly a demand for more and better regulation by the kind of anti-sexual violence activists. And on the other side, a concern, the kind of the feminist critics there, a concern about what happens if it's too broad, and they want the definitions narrowed, and they do want, and it's difficult here, it's like, is it more or less law? Substantively, they want it narrower, but procedurally, they want to make sure that there's sufficient protections for those who are accused. So I think you can really see a pretty direct line between the first sex wars and the seconds. Enter MeToo, it becomes a little more complicated, precisely because MeToo was not a legal movement, right? It didn't come out with like this agenda for law reform. And I think that that's what makes it kind of complicated as we hear these discussions of around sexual harm. And precisely because the law is so hegemonic around this, we think, oh, it must mean you want more laws. And some people do want more laws and some people don't want more laws. So the MeToo feminists, I don't find the MeToo feminists or the feminist detractors are not really taking a very clear position on we want more law or we want less law. Some want more, broader substantive laws, and the critics would be concerned about that. Some are less concerned about due process, and then the critics are concerned about that. So it doesn't match exactly, precisely because it's not a legal movement. But then those of us who are engaged with law and we try to bring it back home to law, then I think we start to see these sort of push and pulls towards more versus less law, substantively, procedurally, but then also about, and I forgot who said this, I don't know if it was Julie or any of you, who said it's about what kind of law as well. And so, in this context, I'm also trying to complicate the conversation around what are we talking about? Are we talking about substantive laws, procedural laws, what kind of substantive laws? And also kind of get a remedial question in there about how can we think about this completely differently?
Thank you. I'm going to have just one last question. Anybody can pick it up. There's so many to the audience. I'm so sorry. There are many, many more questions. We've got maybe 2 minutes left. So there are questions around the pandemic and femicide. There are questions about the hoax in Central Park yesterday and the believability of women and so on, about Indian feminists responders, how Indian feminists responded to the list of academics accused of sexual harassment. We have questions about the violence against trans women of color and exclusion from MeToo and so on. So I'm really sorry that we have to end this here because I want to respect the times and so on. Julie, do you have any closing words before I thank the wonderful, wonderful panelists? Julie?
No, I also just want to thank the wonderful panelists for illuminating so many different dimensions of both the social movement dimension as well as the potential and limits of law. I think that we have actually had a number of different interventions that help us think about different forms of law, or not even law, just different forms of interventions that involve both public policy as well as collective action that may not necessarily become law. And I think it's been a really interesting and exciting panel for that reason. I share Penny's excitement but regret about our inability to address the full range of questions that have been raised. And I hope that there are other panels during this conference where those conversations can continue.
So thank you all the panelists, thank you moderator, and again the audience. We will not be having webinars sessions, the format. Tomorrow it will be more interactive. I thank you for your very thoughtful questions and regret that we couldn't get through all of them. Have a good day everybody. Bye.